So for video summary number 2, we had to talk about chapters 3 and 4. Chapter 3 is about the American legal system. Talk about jurisdiction, which is the power of a court to hear a case and render a binding decision. So it's basically like the court's power for their decisions to be upheld and their decisions to actually have power, because they have jurisdictions over persons and properties. You talk about the plaintiffs and the defendant. Different kinds of jurisdictions, like the long arm statute. You talk about some example cases, like Volkswagen Court versus Woodson. Let's talk about determining the existence of minimum contacts. Talk about venues, which is like the actual physical place, like the location of a court where like the hearing is happening and like the decisions are being made. It's like the physical actual location. Talk about the structure of the court system with the U.S. Supreme Courts and the district courts and all that. Talk about attorney-client privilege and the work product doctrine. The attorneys, the judge, the jury, which are randomly selected individuals from the geographic area of the court. And then there's different types of juries, like a petite jury, which is a jury of 12 people, a grand jury, which is 12 to 23. Indictment is a formal written accusation in a felony case. Talk about the adversarial system. Then talk about the steps in civil litigation, like the pretrial stage, the trial, which is like the jury selection, which are selected through, I'm not really sure how to pronounce this, but voir dire, which is like the oath that the jurors have to take to make their decisions under oath. Talk about mock juries and shadow juries, and then go on to another case example, JEB versus Alabama. Talk about the appellate procedure, class action cases, and then the Class Action Fairness Act of 2005, which sought to limit the legal fees of attorneys. And that's basically it for Chapter 3. Moving on to Chapter 4, which is Alternative Tools of Dispute Resolution. We start out talking about alternative dispute resolution, which is ADR for short, which involves things like negotiation and settlement, mediation, arbitration, mini-trials, early neutral case evaluation, private trials, and summary jury trials. Some advantages ADR has over regular litigation. It's less expensive, it's convenient, freedom to choose, and it preserves confidentiality. Cases can be resolved without a precedent, and it preserves the relationship between the parties. You go on in more detail about negotiation and settlement, which is about the disputing parties informally trying to resolve differences. Mediation is about the parties select an expert in the disputed area to help reconcile differences. So this person will be like, they'll act as the judge in the case. You want to talk about advantages and disadvantages of mediation. You move on to arbitration, which the parties submit their disagreement to a mutually agreed upon neutral decision maker, or like a third party, which will then, I guess, decide between the parties. In arbitration, the award is the decision made by the arbitrator. And talk about methods of securing arbitration. Another case, American Express Company versus Italian Colors Restaurant. Talk about selection of the arbitrator's code of ethics, common uses of arbitration, problems with arbitration. After that, you move on to mini trials, early neutral case evaluation, private trials, which are pretty much what it says. Cases are tried in private by a referee. Summary jury trial is a alternative dispute resolution method that consists of an abbreviated trial, a non-binding jury verdict, and a settlement conference. Yeah, that's basically it for the chapters. It's important to know because it's kind of like, this is more basic legal knowledge that, in my opinion, should probably be known by everybody, because you never know when you'll be involved in a lawsuit. So it's just good common knowledge to know.